Welcome. This is the Domain Name Law Show. We're here every Tuesday, noon Pacific, 3 p.m. Eastern. I'm one of your hosts, Todd Ryan. There's three of us. Myself, Jeff Neuman, and David Michaels. Hey, Jeff, how's everything going with you today?
Everything is good. It's a busy time. Lots of things going on, and I'd love to make a shout out to the people that listen to this because some of you are referring potential clients to me, and I really appreciate it. And just want to thank you all for your confidence in me to refer others' business to me. So thanks.
Thanks everybody on listen to the replay. And there's a few of us in here now. Domain name law, unusual topic. It's not like, a lot of people into domain investing, the domain name legal issues. They're usually only interested in once they have, one, confront them, or they're, obviously needing some legal help. But yeah, I know I've actually had some folks mention to me that they have happy that we do this and happy that you're available sometimes to consult with them. So great, Jeff. I'm thrilled to be on a panel with you and with David. David, I believe, is back in the room now on stage. Hey, David, can you hear me? Are you everything smooth? What's up? Okay, not so much, but he was here, then he left. Now he's back. I'm gonna go ahead and get him back up here. Should work pretty smooth. We'll try to get through today pretty fast. We got some interesting cases, not
Now
real
he's listed as
involved.
a listener,
Yeah,
um,
it says
and now he's out.
we'll see what happens.
You know,
Must be his connection, but
maybe we should switch platforms. I don't know. What do you
I
think,
mean,
Todd?
what are you thinking? I mean, we talked
You're on
about
mute,
this,
Todd.
but Zoom, but I mean, do it on a here. I would always post here.
Uh-oh, Todd's not showing up either. Come on, Todd.
Okay, there I was. I was talking. I was just simply not off mute. But I was going to say, where we talked about it, but Zoom, LinkedIn, I would still post here to a link. Right now we are streaming on YouTube. So as Jeff was mentioning earlier, thanks for the listeners. Thanks if you listen on replay. I know some folks listen to this right here on X. This is just path of least resistance, the easiest way for people to listen to the show on X. It was easy for me, so I figured it was easy for others. And then even if you're not an X member, you don't have an X account, you can still listen to the replay without having an X account. Let's see what start touching on our news. See if David jumps back in. It's usually his connection, but we haven't had too many problems in here over time. But Jeff, what were you thinking? What alternative platforms are there? That I mean, I know there's several, but what were you thinking?
Yeah, I mean, I think it'd be kind of cool to get do an official podcast and get it up on the major platforms like Spotify or Apple Music or wherever podcasts are. Um, this way you can listen in the car if you want. I know it's exciting driving topic, while you're driving.
Yeah, and no, I agree. It's not difficult to do. I could have probably already done that. I mean, I certainly could have got it on the podcast apps, um, but maybe just go ahead and do that. But still, people can listen to. I would just don't promote it. The replay here or the replay, like I said, they can listen to it any time. I guess it may be easier for them to search on the podcast apps, but YouTube. I need to just start putting a link at DNL
Yeah, because
show.
I search for podcasts all the time, and I kind of put in domain names or domain name law, and very few show up. In fact, none show up for domain name law. But if you type in domain name, you'll get like Andrew Alleman's. You'll get a couple like Cum Laude, I think, has a podcast, but not many other things out there. So I think it's kind of worth
Yeah,
exploring.
no, it is, and it's worth doing. So we'll do it. Hey, David, how's everything going? How's your audio now? Couldn't hear you. Could you hear him, Jeff?
No,
No,
but maybe before we do a podcast, we'd have to make sure that it was edited, or to edit out this kind of thing.
Yeah, that's what I like about podcasts is, yeah, you don't hear the bullshit, but that's what I also don't like about them because it can make everybody sound real smart. Can I just cut out all the stupid things I say? Then I'd say about 5 sentences, but they think that guy knows what he's talking about. Um, David, I don't know. I mean, you know the story. Do whatever you think you need to do. Leave, come back. Um, so when you come back, Dave, just come on in and start talking. We'll see if we can hear you. We're going to start on the news. Okay, the first piece of news. This is show number 236. So you're right, Jeff. We probably should coming up on 5 years soon enough. Early next year. So I guess and it's perfect to make ourselves available on the podcast apps because, like you said, very little. You search, we'd be right there. Domain name law. Nobody else is really competing for this this fucking market. Okay, so the first piece of news I was going to touch on was, everybody's already known now. It's old hat. CVC Capital was, acquiring a majority stake in Namecheap. Pretty big news. I mean, I guess now we'll start hearing about what that means. And Richard Kirkendall, who started Namecheap 25 years ago, that's how fast time goes by. And he's, built it. I guess the revenue in 2024 was 400 million. All right, so that's total revenue, not, of course, there's a lot of expenses and stuff there. Hey, David, say something.
Yeah, can you hear me now?
Yeah, as a matter of fact, we can.
Wonderful. It's a beautiful day here, so
Beautiful.
glad to join.
We'll just get rolling here, but no, we knew you'd make it here.
So I think this is, with respect to Namecheap, I think this is obviously great for everyone that works there, and congratulations. And I really think that they needed something like this to really compete with GoDaddy. I mean, they've been doing extremely well within the industry, and maybe through some word of mouth. But with this injection of capital, they'll be able to acquire other tangential business lines, and really be able to globally compete with GoDaddy, who GoDaddy has by far the majority of gTLD registrations. And even though Namecheap is growing, it's still if GoDaddy is, let's say, 40% of the market, or probably more than that, Namecheap is still only 15% maybe. And so it needed this to really get to the next level. So I'm proud of them. I think it's a great deal.
And we see there's always a lot of positive things happen when private equity companies get involved with other companies. People always just look at the negative, like they're going to, try to make things real efficient, and then they're going to sell off this. Well, that can be several years down the road. And like you said, maybe maybe Richard, he's pretty slick. He was looking for the right partner. He didn't know this wasn't some takeover, so he was looking for the right partner to, continue on a certain path. And he did just, really Spaceship just came into existence a few years ago. So,
This to me does not seem like we're going to get it to sell it. This to me seems like we've got it, and the next step is going at some point going public, which would give obviously all his employees and others that hopefully have some shares in the company, a good, nice exit. So, when you get this kind of acquisition for 1.5 billion, it's really going public is the next viable thing.
So who was the other owner of Namecheap? It was Kirkendall, and who else?
I don't know, but I know he's got some partners, and I didn't know. I never did know because I don't know him, and I know a lot of folks in our industry have friends with him. He's been around 25 years. They watched him just like Todd and Ray King over at Pork build stuff from the ground up, and the Rayberry brothers. So, so I know some people know them intimately. Know, I mean, I'm going to be going to Domainer Expo. I'm sure there's some folks there. Braden specifically probably knows, a lot about here's who's always owned it with him. silent partners invested with him. But I know I'm sure there's several, but I don't know, David, who his partner was there. But I'm assuming, and I know he's always been way above water on the business. But there's a lot of companies who don't mind not being real profitable because they're waiting for things like this. Now, like I said, I'm certain his 400 million in revenue this past year. We don't know what the net profits were, and there's a lot of expense with his employees and stuff. I mean, and plus with the investors. So I'd love to know the full picture, only because it's interesting to know how much, 25 years of building, how much debt has been built up, but this should take care of all of it. And if the valuation, like Jeff said, was 1.5 billion, and they bought into a majority stake, well, if they're telling us the valuation was 1.5 billion and they bought into 50% of it, we know that's 750 million. So if it was more than that, so what they do, pump in 800 million, but they could be saying we're going to pump in this amount over this amount of time. Anyway, who knows what the deal is? But I do agree with Jeff that it looks to me like it's strategic partnership too, that they want to grow this thing and likely become a public company, and then you just be in closer competition to GoDaddy. I don't even know what GoDaddy's valued at right now. It must be 15 billion or more than that. Maybe it could be 80 billion. I have no idea. But you can see, so 1.5 billion. They're much smaller. They are than GoDaddy, but it's they have plenty of room to grow. But anyway, fantastic, Richard. Entering this partnership, and he's still, people are wondering, is there going to be still the adversarial relationship with another company? Basically, you can really be edgy when you're sort of independent and private. But now that
Yep.
he's got,
GoDaddy has, I was just checking it out, as of today, GoDaddy's got a market cap of 20 billion.
yeah, so surprised that's not even more. I mean, the way everything that's once you go public, everything's so overvalued. But I'm a shareholder there. I'm really disappointed, Um, but all right. So anyway, congratulations. We're going to watch how this, it's still going to be around. Us as domain investors, you know, I don't know. Maybe there's some attractive promotions to make sure people do not flee for reasons that just because, unknown reasons, because a lot of folks, put the brakes on. Oh no, is it still the same owners and what's going on? But I'm sure we'll hear more about that. Second story I had on our outline, and you can check out the outline at dnlshow.com/outline. And that's the outline with links and everything. But second news article, this was also on DomainGang. Books A Million is the second largest bookstore. Okay, so they're a big bookstore chain. I don't think I've ever been in one. Sort of remember about it, but I didn't know how active it still was. But there was they had to file a UDRP against booksa-trillion.com and books-a-trillion.com, and they won. They won both cases. The panelists said it was actually Don Osborne, so they got a great panelist, considering when you're a brand and you're trying to protect your brand. Don Osborne is a panelist known for transferring names away from domain owners right to the brand, the trademark owner. But in this case, she did, and it seemed like, booksa-trillion.com was just going nowhere, but books with all the hyphens, Books-A-Trillion, was going to some competing links. She just considered it typo squatting, and I, would almost agree in this case. See how you guys feel, but Books A Million, you don't, that's a unusual, sort of a fanciful type trademark name, Books A Million. So somebody claiming Books-A-Trillion, it's obviously playing off of somebody else's mark, just changing the M to the TR. But that was a transfer. I just wanted to ask you guys, you remember Books A Million, and what do you think of this story?
I mean, yeah, I remember Books A Million. I don't think it's technically typo squatting. It's certainly, close enough where they're trying to play off on the goodwill. And so I have no problem with the decision. I just don't think it's typo squatting. I think it's definitely fits within the policy of trying to disrupt the business of a competitor and or trying to pass yourself off as them, because trillion and million are, um, not that they're synonyms of each other, but they're, for all intents and purposes, they're pretty close. And the fact that they compete directly, at least according to Dawn, I haven't looked at the sites. It's pretty clear that this case, should have been decided as it was in favor of the complainant. I just don't think it's typo squatting.
Yeah, David,
That's the problem when you rely on the opinion without doing the background homework. So, yeah, books, a trillion with hyphens, is a unique site. It's very thin. It used to have more links from the homepage to certain books, certain titles, but it only ranked for like 5 or 6 keywords. It was only getting about 80 visits a month. It's they're giving free book recommendations, so it looks like a fair use in that respect because it is about like different kinds of books. I was actually surprised to see that the USPTO didn't make the bookstore disclaim the word books in their registration, but because they got it in 1989, you could get almost anything generic registered back then, and they did not care. That was a loophole back then. So um, now the owner of this domain name is in St. Nevis and Kitts. So yeah, St. Kitts and Nevis. And there's 2 different domain names. The one with the hyphen is not the same owner as the one without the hyphens, but they had the same addresses, and so that was covered. Um, the other thing is the domains are registered through 2Cows, so it's not in the United States. So U.S. trademarks really don't apply because this is an offshore business. There is plenty of decisions according to UDRP perspectives that if you're not in the country, you're not competing. US trademarks are only good within the borders of the United States. And that was a Supreme Court case that got decided a couple of years ago. And, that's good law. So I wouldn't say that Dawn made a good decision. I would say this would have been defensible, but she didn't bother defending it. She could appeal it, but she can't afford it because this thing is not making any money. I checked on Spy Food. So in this case, it's a loser case. It's interesting that the the complainant says that they're the second largest bookstore in America, and yet I never heard of them ever. There's very little search traffic for it. They're a Southwest regional, Southeast regional bookstore with a store up in Pennsylvania and Chicago area, but beyond that, they're mostly in the deep South. So they're mostly unknown.
well, in their defense, you read about as much as Trump. Just kidding. Ha ha. Just jokes. I'm joking. St. Kitts and Nevis and Butthead is what I thought when you said that. All right. If you want to look at our outline, dnlshow.com. I know you were laughing about that Trump joke, Dave. Okay. So when you look at the outline, dnlshow.com/outline, I'm going to jump past number 3 because we're going to get back to that. I wanted to get to 4 and 5 real fast. And a couple things I want to say. I was going to keep it private, but I need some help here. So the ICA has, just announced that they're taking nominations for the Lonnie Borck Award and for their new Trailblazer Award, which was the first time last year. And I believe last year's Lonnie Borck Award, I can't even recall who won it now that I think about it. I know Seigers won. I know Alleman's won. Oh, Richard Lau, I believe, won last year. But anyway, last year I nominated Jeffrey Neuman. Okay. This year I nominated Jeffrey Neuman. Okay. I need more nominations. And I'm not the only one. But anyway, I'm asking you to click on our link. And, reason I say nominate Jeff, I had all my reasons there. I don't have to give you the reasons. Jeff's been integral part of our business. A lot of other lawyers, John Berryhill, I know even David Westlow was like the first winner, but a big advocate, especially as an attorney, for domain investor rights and really helping us. No one's more, in my opinion, deserving than Jeff. But sometimes people, can be a popularity contest. But I'm asking folks two things. One, so click on the link on our outline, dnlshow.com/outline. You'll see B4 2026 Lonnie Borck Memorial Award. You can click there. You don't have to be an ICA member to nominate. So just put in, please for Jeff. If you want to nominate somebody else, go ahead. But I'm asking for Jeff. And then also for the Trailblazer Award last year, Darpin, I believe, won that. And Darpin, I'm not mad at Darpin. Adam, fantastic. But that's like, he just came to the party. I felt like I nominated Chad Fokening last year. I nominated Chad again this year. I've reached out to some folks saying, I think there's no one more deserving than Chad Fokening. So I just wanted to say, if you click on the link, or you can find it in other areas on domaining.com, you'll see the ICA is asking for nominations for the Lonnie Borck Memorial Award and for the Trailblazer Award. I'm asking you to take my suggestion and recommendation and go along with, nominate the guys that I'm nominating. I sure hope to see them win. And it's awarded out at the ICA annual meetup. But like I said, you don't have to be an ICA member to nominate. So for the Lonnie Borck Award, I'm nominating Jeff, and I ask you to as well. And then for the Trailblazer Award, Chad Fokening, FOLKENING.com. But matter of fact, anyway, I appreciate it. Outside of that, I wanted to say tomorrow is a pretty big event that I think I'm certainly going to participate in, or I'm going to attend. Jeff is on the panel, and that is, there's an ICA webinar about the new gTLDs. So about, the next round, and it's called The Latest Intelligence from the Experts. And it starts at 10 a.m. Pacific, 1 p.m. Eastern. It is a Zoom that you can sign up for. I'm certain you don't probably have to be an ICA member, but it is put on by the ICA. So click on the link. That's B5 on the outline, and you'll see September 17th tomorrow. Like I said, 10 a.m. Pacific, and it's going to be pretty interesting. Matter of fact, Jeff, who else is on the panel with you? I had it handy, and now I don't have it in front of me. Who else will be speaking with you tomorrow? Do you know?
So I think I believe it's Sophie Hay from Cum Laude. Geez, I have to remember now. Give me one sec. Go on to others. I will tell you in a second. I should know this off the top of my head, but
Yeah, and I know some of them. Of course, one was the gentleman that we had in here speaking as a guest one time, but I'll let you get to it. Hey, Arif, nice to have you on stage. What's going on?
Hey guys, I'm out actually walking with my buddy. It's a beautiful day here in Montreal. I just had to come up and reinforce what you're talking about, Jeff. I also was going to be nominating him as well. He's done so much for the community, going way, way, way back. But also, even nowadays, these rooms that you guys do. I wish you guys could be nominated as a team as well. But I mean, also, earlier on this year at the ICA, when I was, in phone calls from home for my family health stuff and whatever it was. At the same time, I wanted to stand up and talk about, having us all discuss the scope of the ICA. And, just as I was going a little out of control with my phone ringing off, whatever, Jeff came literally tapped me in the back going, you're going to do it. And he's okay. I knew with him behind me, like I had support for something that's really, really, truly important for our industry. So, he's there in multiple ways. I really, I appreciate what you guys are doing as a team, but with him, I think it's a no-brainer. He's done so much going back so many years, and I really think it would be appropriate. And so, media part of the ICA, I totally endorse voting for Jeff. I think he's just done too much for this community to ignore. So that's one thing I wanted to say. The other thing, also with the spaceship thing, very quickly, I'll just say, I understand why it happens. It's probably not going to be the end of the world, and obviously the 5% was going to go up at some point, right? But I did really enjoy the tenacity of Richard going after GoDaddy, because I think it helps the industry, the competition, right? And the more angry he is at GoDaddy, the more it is. And as an individual, not a corporation under a venture capital firm, he does have a little flexibility. So I do see that flexibility going away a bit, but it doesn't mean it's going to zero. If you see, I asked a question to him on X, and he responded. Right, the response he gave was, pretty much he's still staying in control. He's going to be taking a salary of $1 a year, but control, I guess, is kind of like a weird sort of word because obviously the sale was for a majority share. So whether majority's 99% or 51%, I don't think it really matters in the end because he might be the one steering the ship, but ultimately he might be told to turn in a different direction at some point. I'm going to be positive. I'm not going to say it's going to happen, but I still preferred it being under his control completely because I think that frustration and anger against GoDaddy as the second biggest registrar was a benefit to domainers. So hopefully it'll still be there, but we'll see. Anyways, but yes, go Jeff, go for that.
Thanks.
Go ahead,
Thanks, Arif.
Jeff. Share with them.
Yeah. So yeah, thank you. The other speakers, I misspoke. It's not Sophie Hay, but it's Susan Payne from Cum Laude. It's Krista Taylor, who many people know, who's been in the domain industry forever and advising new TLDs. And then Mark Trachtenberg from Greenberg Traurig, who I believe is the one you were referring to, Todd, that we've had on this show before. He represents brand owners, but he also has represented Web3 companies and others, probably one of the best attorneys in this industry. So I'm looking forward to it.
Yeah, that's it's starting to heat up for those who have just even a small interest in the gTLDs in the next round. Take a listen to this, but the link's on the outline, dnlshow.com/outline, B4 on the outline. And that is, you can sign up for this webinar tomorrow, 10 a.m. Pacific, 1 p.m. Eastern. It's going to be, there's plenty of people that are very interested in TLDs in applying in the next round. And it's really, like I said, starting to heat up because people know they need to start getting their ducks in a row. And some people are, arranging their financing because a lot of folks, it's partnerships that are going to be applying, not just big brands or big companies that can really afford it, because you do have to have your budget all straight and all squared away before you get involved in this. Yeah, Arif, thanks for that, Arif. And I did see, I think I did see your post on X to Richard, and I saw Richard's reply, and I think Richard may still interact, basically go back and forth with GoDaddy. His partners may say, we like what you did. Of course, be aware we're big now, and we don't want to do anything that's too crazy, but we think that's probably part of the reason why they were attracted to that. This guy's tenacious, but he's not afraid of GoDaddy. No one should be, and he's just a competitor. And Pepsi's not afraid of Coke, right? You gotta. So interesting there. The final topic I wanted to talk about before we get to our cases today was somebody made a point. I've been thinking about it, but I don't really have the answer for it. But so when you lease your domain name, now LTO is the new hot thing. Everybody's, without an LTO, the lease to own option, you're really limiting your buyer pool because a lot of small companies need to lease that they don't have the budget to purchase outright, especially depending on what the value of the name is. But when you lease your name, under most of these lease agreements, you are the domain owner and you're responsible if there's any legal action against the domain name or if there's a complaint like a UDRP complaint. So I don't consider that a legal action. It's sort of pre-legal action. But if you get a UDRP on a domain that you're leasing out, well, it seems like, it's really unusual. One, you gotta defend what is currently on the website, and hopefully that didn't play a role in you getting the UDRP. But first, I'll go to you, Jeff, because you're a panelist, and then David. I really look forward to your comment on this of how the domain owner can protect themselves when they lease out their domain names, but yet all these LTO agreements say the buck stops with the domain owner, not the lessee, when there's a UDRP. So, Jeff, have you seen any cases where it's been on a domain that's been leased out, and what can a domain owner do to protect themselves?
Yeah, so I've not had a case myself where, at least that I know, that I knew that a name was leased to own. So I can't say that I've seen that in the UDRP cases I've gotten. But from what I would say is, as the actual domain name owner that's leasing it out, is you really need to have the certain rights in your agreement, your lease agreement. One is that you have the right to claw back a name if it's subject to any kind of um, litigation or UDRP or whatever. But two, even more important, I think, is that you have the right to accelerate the payments if the domain is taken away because of a judicial or some sort of hearing or UDRP, so that the remainder becomes due upon that kind of event happening. So if the name is transferred, you as the domain owner should be able to collect the full amount of the rest of the lease, no matter how many months are left on it, so that you're paid in full, because that's really what you're concerned about. Um, so I think that's very important for the owner to have. Now that may be a whole collections issue, and you still may end up getting screwed because you aren't sure that um, the leasee who's now lost the name is in a position to pay you the rest, or won't just kind of ditch you, and now you got to sue them to recover. So it's not the perfect protection, but I think as the owner of the name, you should do a credit check on the leasee. I think you should get to know them a little bit and be comfortable that A, they're going to use it for legitimate purposes, and B, you're going to get paid the entire amount no matter what happens. But there's always a risk. So that's just what I'd say.
Yeah, I'm looking at the spaceship legal terms for the buyer obligations, and it specifically says that the buyer is not allowed to use the name for any illegal activities, including but not limited to fraud, phishing, distribution of malicious software, or infringement of intellectual property rights. So, as a domain owner, if I'm leasing a domain name through Spaceship and I'm monitoring my domain name that I've leased out, I should be checking to see if it's infringing any trademarks or close to it, and notify the buyer, say, hey, you can't use this domain for that particular purpose because it violates the lease to own agreement. Cease and desist, change your website immediately, or I will take back the name. And you have the right to do that. So, at least it looks like you do.
Does a spaceship have the automatic acceleration?
I haven't read the whole thing yet, but that would be useful.
I gotta believe it does. That if any reason you lose the name, the lease is accelerated so that all payments become due. If not, that would be a huge oversight.
Well, and
Well,
the
I'll
thing
mention
is,
that
why would they pay
to
anyway,
Bill.
right? I mean, why would all payments are due? Due? Okay, what the name's been taken away from me, and you're telling me the payments are due? I mean,
Yeah, but you violated the lease, and yeah, you'd have to go to court to enforce it, but at least you'd have a claim to it. And yes, it would suck to go to court to have to get it, but you'd be entitled to it. And for some names, I mean, if you sell, $1 million name, but you've only got collected 100,000 of it, it's worth going to court to get the 900,000.
no, no, absolutely. I will say absolutely on that. I can't, now when I'm thinking about these 6 and 7 figure leases, boy, they're just really taking a chance by going with these marketplace platform legal agreements. I mean, I want to quickly say, I was thinking about it, and then Anthony brought it to my attention too when I was mentioning I'm I was suggesting, and now I've changed my mind. I'm just kidding. I was suggesting you nominate Jeff Neuman and for the Lonnie Borck Award and Chad Fokening for the Trailblazer Award. Uh, of course, you can nominate anyone. Those were who I was, sort of lobbying for, and I really think are most deserving. Well, when you nominate, you must have the person you nominate's email address. So if you look on our outline at dnlshow.com/outline, or you could just go to dnlshow.com and click on the outline button at the top of the thing, you'll see I've added both Jeff and Chad's, their name, full name, and their email address, because it is true when you nominate, you need to include the email address of the person you're nominating, which unusual because a lot of us know each other close enough. We're like, I have their email in my fucking contacts. Excuse my language, but a lot of folks are like, hey, I admire this person, or this person has helped me, or like Arif said, we're listening. You're not. You know of some people that you'd like to nominate, but you may not know their email address. But it is required when you're nominating. So I put that on the outline, and that's going to be on our outline for weeks to come until while the nominations are still open. So if you're just listening and you're not on a web, you're not on the website right now, I'm going to go ahead and say it for people to listen to the replay. But Jeff's email address, his best one is Jeff, Jeff, at jjnsolutions.com. And you can reach out to him too if you have any, you need some legal consulting with regards to domain name law or IP law. You just reach out to him. But that's the email address needed for nominations. In Chad Fokening, his email address, ECORPCOM, ecorpcom@gmail.com. I'm saying that for people that are listening on a replay and want to write it down and don't want to go to the website. But anyway, the website is where I have the link to the nomination, but you can also find that on the ICA website, which is internetcommerce.org, and on domaining.com. You'll see it around. You might even get an email that says, hey, nominations are open, but I'm not going to, I've already beat it to death, but I will be bringing it up probably for the next several weeks. All right, so yeah, about the LTO, I guess we're gonna hear some unusual, damaging stories, I suspect, in the future of a domain owner losing their name early on after someone has leased the name, they've done something with the name, or people are now buying names so they can then try to, call and sell them. Can you imagine if you bought a name on LTO for $50,000, you've made one payment, now you contact a trademark owner and say, hey, I own this name, you want it for $80,000, try to make a quick, after committing quick 20 grand, quick 30 grand, and then that trademark owner says, you targeted us, you just acquired the name via LTO, now you've targeted us. That is, and I could see a panelist like Don Osborne saying, that's exactly targeting. They purchased it with the intent of going to selling it to this one person. Seemed to me like a pretty easy case for a brand sided panelist to decide on. So I can't imagine.
Yeah, and the other thing I would say is that, and I don't know, I'm just trying to think. I'm thinking out loud of how best to do it. But you should be able to have your email address. Well, I guess the registration's in your name, right? So it should be in the owner's name, or the owner needs to um, get all communications. It needs to know when there's a UDRP filed. So it shouldn't put in the new owner as all the information. And I don't know if registrars offer a way to um, ensure that multiple people are given notices with respect to the domain. I'm sure there's probably a way to do that, but the owner needs to, if the owner doesn't want to put its own information in the um, who is or registrant RDDS registrant database, it should still make sure that it's being copied on any notices that the registrant gets, to make sure that the leasee responds, or you respond on behalf of the leasee, to make sure that it's not a default and goes to someone like Don, right? so you can file that response.
This is the topic we're going to touch on again because it is going to be something that affects domain owners and more negatively affecting. So they need to have a proper agreement in place with these platforms that are offering the LTO. All right, on a Thursday, I wanted to mention. So tomorrow morning, for me, 10 a.m. Pacific, and that's 1 p.m. Eastern, we got this gTLD webinar. You can find the link on our outline. On Thursday, I'm going to be heading over to Las Vegas for the Domainer Expo, and Josh and I do our DNX show 10 a.m. Pacific on Thursday. Josh is going to, launch it because I think I'm going to be still in the air then. It's a short flight. So as soon as I land, I'll jump on the DNX show. But Josh is starting at 1 p.m. Eastern as we normally do. So we look forward to seeing everybody on the DNX show on Thursday. I wanted to mention a week from Thursday, or maybe 2 weeks from Thursday, we haven't scheduled it yet, but Monty of Right of the Dot, Monty Khan, and Scott is going to appear. I was going to let you know, Jeff, so you can join us. He said there's some exciting news about .hip hop. Monty's also launched another company, but we were going to talk about the liquidation auction. Eric, if you'll be interested in this, Monty's doing a liquidation auction for domain names with GMB. It's that platform where if you bid and you get outbid, you get a little piece, you get paid for that winning bid. Basically, you get paid to participate if you're not the winning bidder. So he's basically, Monty said, Todd, I'm working on this, and this, and I want to talk about the Dubai auction, but I want to talk, of course, I asked him about, NamesCon, the live auction at NamesCon. So we have 5 or 6 topics we're going to touch on with Monty Khan and Scott. What's Scott's last name?
Pruitt.
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 I didn't know how that slipped my mind. It was just like that. But anyway, so Monty Khan and Scott Pruitt of Right of the Dot, and of course Jeff is part of their crew, and from .hip hop to Right of the Dot and assist. So I just certainly hope Jeff can make it too on the Thursday. So it's either going to be the 25th of September or the 2nd. Monty and Scott are going to get back to me and tell me which day's the best for them. But so we really look forward to that. Now let me get going on our cases for today so we can get out of here. The first case is Magic Men, MAGICMEN.com. Okay, you can imagine Magic Men Holdings, this Australian company, is the complainant versus Wayne Ball, who self-represented himself, this domain investor who bought this name in April 2002. Now, this complainant has a trademark since 2014, but they, there wasn't, I guess they, it was like, what do they do actually? Now, their trademarks in the adult services, the party area. So I don't know, somebody deduced or did some searching that they're male strippers, which I think a lot of us have experience in that area. Anyway, so those sound like the guys from down under, but like the B team or the C team, because I know the other guys were the more famous from Australia. Believe me, I know. I followed this stuff. So Magic Men Holdings was the complainant. Wayne Ball was the respondent, the domain owner. And this complainant said, like I said, they own the trademark since 2014 to Magic Men. They think they have a right to this domain name. So they contacted a broker. If they had a right to it, I don't know. They contacted a broker right here in July 2025 to buy the name. So they must have known they didn't have too many rights to it. They contacted a broker. The respondent, I guess there was no response. The broker said, I'm going to keep reaching out, but I'm not getting a response from this domain owner. The respondent, well, I'm not going to give it away how the respondent replied. I'll let you guys do it. First, let me go to David. David, so you can have a few things to say about this before we take all the meat off the bone, and then follow up after that, Jeff, and you guys can give the decision here. But David, take it away.
All right. So the name was registered in 2002. The owner says he has an interest in magic, and that's why he registered it. And there is no website now. There is no history on Internet Archive, so it's never been used. So the complainant is saying, well, wait a minute. This is passive holding. The name has never been used. and we have a trademark in Australia, we deserve the name because passive holding is not legitimate in their book. They must be Australian or something, because under the .au rules that might work, you know, but not in the United States, not on the .coms. So they didn't get the trademark until 2014. They didn't get incorporated until around then, 2013 or 2014. So he had the name a decade before they existed. So how's their bad faith registration? There isn't any. So that's a solid, defense. He could have just stopped there. He didn't have to say about interest in magic, but I guess that helps differentiate himself from these Chippendale wannabes. Anyway, what do you think, Jeff?
Wow, Chippendale wannabes. That's pretty harsh. Um, I kind of think of when I saw Magic Men. I think they were kind of, um, maybe trying to go after like the Magic Mike franchise. But in either case, the they I agree with you that the panelists did not need to go into all the evidence that the respondent put in, but the respondent said, "Look, I've been interested in magic for forever," and apparently sent in a whole bunch of information about the magic acts and or shows or presentations he's done, and the complainant tried to argue that the domain wasn't hasn't been used, and therefore that's another indication of bad faith. But as the panelist correctly points out, there's no requirement that you use the name. And so the fact that it hasn't been in use with the website is certainly not indicative of registration and use in bad faith, especially because, as what David said, it was registered. Um, the domain name was registered way before, a decade before the Magic Men uh, complainant brought this case. And I think they also said the Magic Men tried to say that they have a common law usage since 2012, which still doesn't meet the date that uh, it was still well after the date the domain name was registered, so it didn't really help them. But they didn't provide any evidence of it. And unlike other cases we've looked at, if you've registered the domain name before the registration issues or common law rights are established, you don't have to show legitimate rights in the name. In other words, you don't have to show that there are demonstrable preparations to use the domain name because you registered the domain name before the trademark existed, so you could never be said to have registered the domain name with the complainant in mind. And so, all of those arguments raised by the complainant just are, moot because of when the domain name was registered. And um, given all of those facts, it's not a surprise that our RDNH, I think, was found. I'm pretty sure in this one. Um, so, yeah, I mean, I think it's a pretty clear case.
Yep, it was RDNH. Andrew Lothian was the panelist in this case. So he denied the complaint. He said that this complainant abused the system. So this Magic Man, and I told my wife, she was behind when we left, I said, yeah, these guys filed this case against it. She said pictures or it didn't happen. Well, that's pretty sneaky of her to say. Anyway, so she, so this guy, the Magic Men holdings company, right? They filed this case. Since we, people in our space who've listened to our replays, listen to domain name law, they learn a lot about the UDRP. And in this case, the complaint is filed, the respondent answers, he answers for himself, and then the complainant, you've heard us talk about before, the complainant files these supplemental filings, okay? Filed 2 of them. Now, you guys know, because we've mentioned it before, you're only supposed to be able to file a supplemental filing if you're a complainant if there's some material facts that have changed or something left out. Basically, what is it, Jeff? When are you supposed to be allowed to file a supplemental filing in a UDRP, meaning you can't just add on to your complaint if you forgot something. So
Yeah, I mean, the complainant, who's usually the party that does the supplemental filing, can only file if there are some facts that are presented in the response that were or couldn't have been anticipated. So, or there are allegations in the response that could not have been anticipated. So, for example, um, in a case where the respondent claims reverse domain name hijacking, generally panels will allow a complainant to respond to that, not to add additional facts to the complaint, but to respond to that particular thing. In addition, like in this case, I would say the first supplemental response was okay because the respondent brought up issues of being into magic and has been doing this for years, and brought in a bunch of other evidence that I guess because there was no website up there really could not have been anticipated. So I would say the first one, there's an argument for considering that one. Certainly not the second one. Um, you know, and like I said, if the complainant responds, then it's only fair to allow the respondent to file a response. Um, in this case, like you said, there was the complaint, the response, the supplemental filing from the complainant, a supplemental response from the respondent, and then there was a second supplemental response by the complainant, and the respondent had asked to be able to file like what's called a surreply, essentially, to the second filing, the second supplemental filing by the complainant. But Andrew Lothian said, no, you don't need that to do that because essentially I'm finding in your favor anyway. So we don't need to see that other reply.
Yeah.
It's pretty unusual for you to get that many filings, but yeah, as a panelist, you should be pretty strict on when you accept and when you do not accept supplemental filings.
yeah, the point being, the complainant should be complete. The complaint should be complete, and there really should be no supplemental filings because the panelist is not letting people, here you go, you answer back. You guys keep going back and forth. It should have been in your complaint and in your response. Andrew Lothian allowed the supplemental filings in this case. I didn't even think, the first one, okay, I don't, you said, okay. I was like, I thought he was probably going to deny both of them. I was surprised when he accepted both of them, but then he did deny the complaint, ruled RD&H, so I can see why he told the respondent, no need to keep answering this guy. I've taken all of his information and he's going to get ruled against. But I did like that David brought up that the magician was like, hey, the magician came up with receipts from like the 1990s saying, look, I contacted my local magic shop and here's when I was trying to get a fucking wand or a deck of cards and they were out of it. He was showing he was on a waiting list. Basically, he's like, I'm an amateur magician. And anyway, he's just, fun. And we know, yeah, I mean, he wasn't lying about it. He did answer himself. It's better to add extra stuff than go real thin on your answer. So he did a good job. He appealed to the panelist. The panelist also knew it was, the complainant was just trying to take the name, but that was the domain magicmen.com. I'm sure the gentleman wished he could have got Magic Man, but that was probably taken. But magicmen.com was the domain name. Fairly valuable, I guess. But anyway, so the domain owner got to keep it. This next case, long domain name, but anyway, it's thedigitalrenegades.com. 3 words, thedigitalrenegades.com. This domain was just registered in 2020. I say just registered in 2020. The complainant in this case, Digital Renegades, is the complainant. They have a trademark on the Digital Renegades. Just this year, 2025, is when it was registered, approved. The respondent in this case, Evan Morgenstein. So this company, Digital Renegades, files this case against Evan and says, well, let me see here. It says I wrote down, these are my handwritten notes. The disputed domain appears to be used for digital marketing. And Evan Morgenstein was the respondent. Evan Brown was the panelist. David, what did you see in this case? I'm going to give him it was a complaint denied. So the panelist said the domain owner gets to keep their name, but why do you think that the respondent won in this case?
Well, the respondent's trademark didn't get it's actually just got registered recently. So they applied in 2023. They got registration in April 2025. So their claim, they have to disclaim the word digital, and they're doing digital marketing services, pay-per-click advertising, social media marketing for clients, and sales promotion. So that's new. How did this Renegade talent management, because the digitalrenegade.com is forwarded to Renegade talent management right now. So I don't see a problem with that. Um, they have featured different people who are renegades in industry, and like they basically do business, nutrition, lifestyle. They do this, that kind of stuff. So they're not doing pay-per-click advertising. They're doing talent management. It's a different field. And renegade is a generic term.
Well, it seems like
So what else is there?
Well, it seems like they had been using it for digital marketing, because digital renegades sounds weird. But Jeff, you can chime in here about. So this respondent said they tried to resolve it with the complainant. Basically, it sounded to me like the domain owner was about ready to give the name back. Like, hey, I don't want to be accused of this. I did have some links up earlier to maybe some digital marketing that was similar to what you guys do, but let's try to work this out. The complainant didn't reply. So then but the didn't reply, probably could have got the name in a mutual, some type of agreement. But then the panel said, well, the complainant's claiming that they first used it in 2016, this mark, their trademark, like David said, was 2025, but they didn't provide any evidence of, their mark going back that far, because that probably could have maybe made him successful in the case. But anyway, so this sounded like they was going to give up the name. I tried to reach out to the complainant. He didn't reply. The panelist says, well, you get to keep the name because they didn't do a good job with this complaint. But anything you notice about this case, Jeff?
Well, I mean, we don't know what the quote settlement letter, whatever you want to call it, what it said, whether it said he was going to give the name, or he'd sell it to them for some kind of cost. So we don't really know what it says, but yeah, generally it doesn't look good for a complainant not to respond. Yeah, unless it's the response was, hey, we'll sell it to you for $5 million. Who knows? But look, this is kind of an open shut case, right? The rights didn't accrue till well after the domain name registration, and you're not going to win in that case. A complainant's not going to win in that case.
Yeah, and the complaint, like I said, they said we've been using this since 2016. Well, the panelist said provide evidence of it, and when you claim to have used a name, and a lot of companies do say we didn't get a registered trademark until this date. And that's how I think most smart companies do. You get a trademark after you've already been using it, meaning it's successful. Because I think, it's usually, I consider it novice companies who try to get trademarks here in the U.S. intent to use. When you don't have to do intent to use, when you can just get a trademark without using it, like in Canada or some of these European places, sure, go ahead and get your trademark. In the U.S., you're not going to get it registered until you're using it anyway. So I always think that it's smart.
No, but your intent to use establishes your priority date. So if you aren't using it yet in commerce and you're just building the product and it's not going to launch for 5 months, 6 months, but you want to stake your claim, you file the intent to use, and then your date doesn't go. It goes back to the date you filed the application, not the date you first start using it. So if you file an intent to use today, let's say September 16th, 2025, and you don't start using the product until March 2026, you will have been considered to have rights since today, September 16th, 2025. So there's definitely a role for uh, filing an intent to use, but you're right. If you're going to launch tomorrow, or it's already in use, yeah, you don't file an intent to use. You file a use based.
I was going to ask quickly that there is a timeline for that, right? Like you can't just register and assume that you have 10 years to do it. It's like 2 or 3 years, or something like that. That you have to use it.
You have 6 months from the date in which the notice of allowance is issued, right? So the notice of allowance, it usually takes, even if even if it's a perfect application that doesn't have an office action, you're still not going to get a notice of allowance till close to a year. And then you have 6 months from that notice of allowance, and then you're automatically entitled to one additional 6-month extension. So, you have plenty of time to start using it. Yes, there's a cutoff date, but if you can't, if you're not using the mark within 2 years of when you file the application, you probably don't deserve the registration.
Yeah, I agree. Thanks for the information. Yeah, thanks.
Yeah.
So it's interesting that the complainant was actually using renegades.digital as their domain name, even as recently as 2023. And like there was no content on digitalrenegades.com before. It started getting forwarded to renegades.digital in 2023. But before that, it was just a dead white page, according to archive.org. But in 2023, they didn't offer PPC advertising services. They only offered custom websites, website care plans, business class email, and web hosting. None of those things are in the actual trademark registration claims. They actually claim something else. So they're claiming digital marketing services, pay-per-click advertising services, social media marketing for clients. None of these things were used since 2016. So it's a total lie.
Liars. Jeff, okay, so I agree. Jeff's right. Stake your claim, but if you have your if your intent to use isn't until say next year, Jeff, say at June, we got to get on to our last. Your intent is like we're not going to launch until next year because we're building our locations. Basically, we're not launching until next year at June. We filed our claim. We filed our trademark now, and we know just trying to like our stake our claim. But then when we actually start using, then we'll let the trademark office know. Well, um, now if someone starts, anticipating someone, you can prove that someone's anticipating your trademark by looking at the, you know, companies that are applying, and companies do this. But I guess my point I was thinking was if you apply and you're not using until next year, you don't have a registered mark until next year. All this stuff that you're doing, you can go after a company if they were, like I said, anticipating your mark. But most people don't look at. We don't know who's applying for marks all day long. Basically, if I don't see a mark today that's active, I'm not obligated to look and see, well, who has anybody applied for a mark? If they've applied for intent to use, good luck to them. I mean, I might beat them to the punch. Now, if I'm doing that, like I said, I'm anticipating their mark, so I launch a store the same name as them, just faster. Sure, I could be in trouble for that, but I guess I was just getting at, people normally don't know about others filing intent to use, and I don't know, I'm trying to come up with some bullshit to answer myself, but okay, you know what I'm saying. Let's get to the next case. So Jeff's right. You want to, if you really intend on using your mark, file as soon as you can. It's certainly only going to benefit you. It's not going to hurt you, but you can't get your registered mark in the U.S. until you are using it. The last case we're going to review is Gucci.app, Gucci.app. Okay, so sort of an interesting case. What I found interesting was I didn't know it was founded Gucci in 1921 by Guccio Gucci. His first name was Guccio. So that's the most interesting part of this case. Guccio, Guccio Gucci. So the Gucci brand makes apparel and accessories. Like I said, I've been around since 1921, so trying to learn something here. The brand was valued in by Forbes 23 billion. So not much bigger than the market cap for GoDaddy. Jeff said was 20 billion. Yeah, it seemed to me like Gucci much bigger than GoDaddy, but maybe not. Okay, so they had a 1997 trademark. They've been around forever though, so they could easily, in my opinion, show common law rights there. But you still got to show it. But the point is, they're on Gucci.com. This domain owner out of China, Tao Yang, was registered the domain name, interestingly, in 2019, had it for a couple years, but during that time, Gucci had sent him a cease and desist letter, and he was probably thinking, why don't you send me a handbag, send me a cease and desist letter, and he told him, I have future plans for this name. I have such important plans. He let the name drop. So he let the name drop, and then he re-registered it in 2022. So it's unbelievable. Then the complainant and the respondent talked in March 2023, and the respondent asked for $15,000 and said, that's just for my expenses and reimbursement. And I'm certain if he would have probably been able to show these were true expenses and reimbursement, that's, because people always say, give me money for the time I've worked on this, but it's not really hard dollars where you can show, look, I spent $15,000 with this domain developer or whoever. But anyway, he asked for $15,000. The respondent, well, let's see, said they were, well, I won't get into their response to the UDRP. I think it's interesting. I'll leave some for you guys to talk about. But the respondent in this case asked for $15,000 for the domain name. Gucci said no, filed this UDRP. They filed the UDRP, and the respondent replied via email. And I love that. I think it's better than not responding at all. But who wants to pick up about the respondent's reply via email? I like their response. I'm not saying it was successful.
So something struck me here. The respondent contended that he had received many offers to purchase the domain name, or offers to purchase the disputed domain name, but he had rejected all of them. And the complainant's lawyer is Studio Barbera. Let me tell you a little bit about them. They're run by Luca Barbero, who is actually a UDRP panelist, and he has a pretty big firm in Italy. And he is employing people who are trying to make offers on domains, lowball offers, $50 or whatever. And if you ignore them, or if you counter offer, you want a lot more money, but they'll keep all that correspondence. But in the correspondence that I saw, they will say, oh, but we're going to, as part of our business plan for our future client or prospective client, and it would really look good for me if I can get it. So they try to pull your heartstrings, but they're all working for Studio Barbero. Now, the biggest mistake this respondent made was responding with a $15,000 demand. That he expressly requested 15,000 USD as reimbursement for alleged expenses, or he offered to alternatively to lease the disputed domain name. But guess what? That doesn't work. This is a famous brand. What could have worked is, oh, that's my last name. I'm Asian, and that's an Asian last name, and here's my defense. Or let me just respond currently saying, look, oh, there's a brand here. I didn't know about this. Let me talk to my lawyer. And that's it. Don't respond with anything more. What do you think, Jeff?
I don't think anything would have worked in this case, right? The fact that he registered it and then dropped it, after the cease and desist letter, which was fine. And then the fact that he re-registers it almost like to rub it in the face of the trademark owner. Look, nothing requires a trademark owner to get every single name, every single a domain name in every single top level domain. It would just be ridiculous. Ridiculous expense for names that you're not going to use. Um, so there are a lot of mistakes by this respondent. But, look, there are certain brands that are known worldwide that are famous. And for anyone to argue that they just never heard of them is, your eye starts to roll. You roll your eyes. Come on. Um, there's not a huge number of these companies out there, but there's enough where, yeah, people know them. And I'm sorry, people know the term Gucci in China, right? Is that what this was in China? I remember it was Chinese was the language, but um, you know, for God's sakes, they sell enough counterfeit Gucci bags there that they know what this is. Um, so there was no way for this case to be won. Sure, I guess if their last name was Gucci, really was, then okay, make that argument. But uh, to anyone not named Gucci, good luck. Right? Even if you want to use it in connection with something that's uh, non-commercial in nature, first of all, a .app would still never be something that normally top-level domain extensions don't figure out into the equation of the analysis of whether a name is infringing or not, or is likely to cause confusion. But in this case, if you're going to register a .app and make a good faith argument that it's for non-commercial use, again, I wouldn't bother with any famous marks like this. There's nothing really you can argue, um, and you're not going to sell it for a big payday. So that's all I could say on this one. As soon as I read the domain name, it wasn't hard to figure out what was going to happen.
Yeah, let me tell you how I think okay, complainants always make claims that they can't back up. And many times the panelists are smart enough where they won't take just a claim without evidence. But sometimes complainants make so many claims about a domain owner, and when the domain owner doesn't respond, the panelist says, if they've made a pretty good case. They haven't submitted evidence for every claim that they've made, but for some of them. So we're going to go ahead and believe that somebody was sending out spam emails or was impersonating an employee, or basically, I just don't trust complaints all the time. They'll just say whatever they want. They reached out to us. They'll just make all sorts of claims that they don't back up. I see it all the time. But then, like I said, good panelists know if you don't back up the claim, then we're throwing it out. But what I would have done if I was and I'm not saying lie, but if I was the panelist here, or the respondent, the domain owner, I would have said two things. I would have said, I sent them an email after I dropped it and said, hey, the domain's available. If you guys want it, get it. Otherwise, I'm going to, re-register it in a year from now, and I'm going to use it because in high school, my nickname was Gucci because people thought I was always, this real flamboyant. I was really, just some fashion person who was only like designer brands, and I'd submit like a picture of me in high school with my name Gucci under, like, most likely to, be a Paris fashion.
And as a panelist,
Yeah,
I would laugh
you would laugh
at your attempt,
and
and
you wouldn't believe
then
me that
fight against you.
my nickname was Gucci. Well, what if I
I
showed
don't
you an
care
email?
if it was Gucci.
Well, but the thing is,
Like,
but no, that's like when somebody's nickname's Lambo. You can say the reason why my name is Lambo is because I used to drive a Lamborghini, or I would write on my wall, someday I'm going to own a Lamborghini, and all my friends knew about it. I mean, you're allowed to have a nickname, and
yeah, and how did Lambo do in that case? They lost.
yeah, well,
I mean, the respondent lost.
Yeah, well, because the panelists didn't believe that
Exactly.
his nickname was Lambo, but there are plenty of people with their nickname Lambo. I guarantee you, there's somebody out there nicknamed Gucci, fucking rappers, Gucci Mane. Okay, so there's somebody out there, uh, there's a lot of folks that have a nickname as a famous fashion brand. I could tell you that. I know there are. Now, it maybe not in this case, but I'm just saying complainants make all sorts of bullshit claims. What if he would have said, "Hey, here's my email that I sent to him saying the name's available. You have a right, go ahead and get it if you want it. Otherwise,
I would still
I don't
say
know."
I would still say that what I said earlier, which is there's nothing that requires a trademark owner to register their mark in every single TLD. So your email saying I'm going to let it lapse, but if you don't pick it up, I'm going to take it again. That's almost another kind of form of blackmail, or it's not a legitimate reason.
I'd say to you are my friends and my grandma allowed to call me Gucci or not? They call me Gucci, so you don't know. They call me Gucci, and that's how I'm sticking. Anyway, so
Yeah, my parents call me Pepsi, right? I don't know.
okay, so but you're right, Gucci. That is a tough one because we people in the Web3 space I have Gucci.en or .eth or Gucci. Well, that is going to be a tough one. I mean, of all, and
And with a dot app, right?
yeah.
It's also kind of like could someone say I'm a huge fan of Gucci, and that's why I registered it? Yeah, but dot app, really? You're going to build an app? Like
But what if your
it
dog's name
just
is up there? How many animals are named Gucci? I bet there's tons of them, and I bet there is. And then somebody says, "Well, so I was going to do a pet app. That's not going to infringe on their thing."
All
I'm
right,
just saying
let's take
alternative.
a. I would love to be able to take a poll amongst the people listening to this and say how many people think there's actually a legitimate reason, or there's anyone nicknamed, or even if you said my dog was nicknamed. I mean, look, I fight for domain name owners' rights, but there's only so far you can go without looking. Um, well, I won't say it, but you know.
Well, Jeff, I wanted to mention this gentleman's answer because his answer was he replied via email. This domain was lawfully registered through open public channels, and it is true. That's why we wonder, why can we even do it if there's absolutely no, what is the one way that it's okay? If the one way that it's okay is to say it's a site about, I don't think these products are worth it. I think Gucci's overpriced, so I'm going to do a free speech type site. There is some legal way to use another
Sure,
person's mark.
sure.
They
There's
might not have in this
definitely
case,
legal
but
ways.
this guy responded, "Hey, I lawfully bought it through open public channels. I've done nothing with it. So how can you know what my intent was? My intent, say, what if, that's always felt about when I register a name. My intention is to only do legal things with this name. So I'm going to stay in that subset of what legal uses can I use this name for. So when I buy a name, I always know never step outside that bounds. Before you do anything, always, check and make sure. So that's why I would say even with a Gucci.app, there is some legal. That's why the registrars let you register it, because if there was absolutely no legal, you know, uh, way for you to use this domain name, then they shouldn't even be allowed to offer it. But yet, they do. So yeah, okay. Hey, Ragu, what do you want to say before we shut this baby down?
Okay, that's my turn now. I was thinking it's going to be the end of the show so I can talk. Um, so I have few questions, but I think it was funny about this dog business and cat business. You stealing my ideas. Anyways, um, Todd, happy birthday, belated happy birthday to you, which I forgot to say earlier. Um, I wanted to ask you, and don't take me wrong, please. How do you pick 3 cases or 4 cases when you come to the show?
Well, I get drunk on a Friday night and then I throw a dartboard. No, usually I'll go to
Yeah.
udrp.tools. To be specific, usually I'll go to udrp.tools. That's Nat Cohen's created that website, but then I'll look at cases that I think are generic names. I'll look down the list of recent decisions of names that I think, well, that's generic. No one should really have rights to that. And then I'll go and see if that's a transfer, then that's probably an interesting case. This past week, I couldn't, most of the names, when you go through these UDRP cases, most of them are like I said, Amazon hyphen this, or you can see that it's somebody cyber squatting on someone's trademark. So when I see it's transferred away, I think that's not interesting. All these are pretty much clear cut cases of cyber squatting. So Raghu, I normally look if I see something like you know um, something that's generic like brownhat.com and it's transferred away. Who could own a term like brown hat? I mean, it's so generic. So then when I look at the case, usually there's something interesting in there for us. This past week, I didn't find many interesting cases, so I was looking through some of the blogs and I saw really DomainGang had mentioned Magic Men earlier that I'd read about, and then I think he may have had either the digital renegades. But so I'll look first at udrp.tools and then I'll look at the blogs and just,
Or,
you know,
yeah, or sometimes I'll have a case,
yeah.
or sometimes one of us, Mike, David, Michaels, or I would find something and see it, and then notice something about it and kind of make the recommendation. But yeah, some weeks it's not very easy.
Okay, so that's great. This is exactly I wanted to hear, and I'm very happy to for this answer. But I have an idea for you guys too. So think of a case where, as we listeners or learning and participating, think the way we would give an answer means like let's say a case comes in, you're looking at the case, and we all agree with it. Okay, and if we all agree with it, the scenario, and the case wins. I like to hear this type of cases as well, not always going against it or against obvious of trademarks and coming up with the surprises. So if you guys can pick up once in a while a case where we all agree with the winner and case won. Do you understand what I'm trying to say, you guys?
Yeah. Yes, and those are going to be very easy to come up with, and I'm glad you mentioned it. I've always really tried to make it, and like Jeff said, so Jeff and David will send me, send an email amongst our group and say, hey, let's talk about this one this week. It's pretty interesting, and we're always looking for those cases that aren't real straightforward. But I will keep what you said in mind, and I will add some straightforward cases because, matter of fact, I'm going to UDRP tools right now just to give you an example. The dozens that are so straightforward that you're going to think, yes, we would all agree on them. And
Yeah, and the reason for me is so I can ensure the what line I'm thinking when I'm investing in a domain name. So I made the right choices based on that thinking. You know what I mean?
yep.
Even though we are very careful when we are picking up a name and deciding for it
Well, I'll give you
and
a
keeping
couple
all this.
examples, Ragu. Sorry to get
Yeah.
it. RocketPlayCasinos.com was transferred because there's a Rocket Play, the company, and there's Rocket hyphen Play, but also Jurassic World Evolution 3. Okay, so you can see that was. I didn't even look at the case, but I'm sure it was. The who owns Jurassic World? Is it Paramount or Warner Brothers? I don't even know who does that. But I'm looking. That's on the forum. So that was Universal
Yeah.
and Amblin Entertainment. Okay, so we can see if we went through that case and I went through it, you could probably understand why did that company. Why David Sorkin was the panelist on that. But Jurassic World Evolution 3.com was transferred away. Well, we would all probably agree if we go to the facts of the case, this person got it. What they didn't respond. It would be we would all agree this was a transfer. And there's most cases are like I said, 95% of them are exactly that. I saw there was one I was going to bring up with statefarm.com. And it was a case that was transferred. And immediately when you think of it, you're thinking, well, yeah, State Farm, that's them. They should win that, possibly win that. But then I know with real estate agents, or I'm sorry, insurance agents, you do have a right to use, if you're a State Farm insurance agent, a lot of State Farm agents will have State Farm in their name. They're limited, but they can use it. So I thought this may be an interesting case. In that particular case, real estate agents, or I'm sorry, insurance agents. Who's off of mute? I can't see because I can hear myself. But anyway, with State
Todd, I
Farm,
think you actually
oh sorry, with
put
State
yourself on mute.
Farm, I'm looking at it. There was an agent who was like about ready to take a job and become a State Farm agent.
Uh-oh.
He eventually didn't
Yeah, it's
pursue
strange.
it.
To me, it shows he's still talking on the video, on the icon, but I don't hear him either. Is there static?
Yeah, we'll just have to wait till he see how long it takes him to realize that he's talking to himself. He's probably scrolling
While I
through.
have you on, well, I got a chance here. So I ran this Gucci.app through an AI assistant. It's the basic one that's available on Poe. And the one that comes out to me or strikes me as
That operates all throughout the world.
true, but like for example, and maybe this is a wrong assumption, but if somebody shops at Gucci, would they also shop at the competitors, or they would just be wearing one brand because that's their identity? I don't know because I'm not in that.
Oh, but if you're going to use Gucci.app,
Mhm.
then that should only be for discussions about Gucci products.
Right. And
They'd
obviously,
have to be very careful.
yeah, and you can't really put affiliate links in there because Gucci has an affiliate term for their website. Says you can't use our brand in your domain name. A lot of these affiliate partnerships all say the same thing.
Right, and you can't really make money from, you can't really be using it in a commercial sense and deriving money from, advertising and other things. So it would really be extremely narrow.
Well, could they have a subscription model where for premium features where it actually does the weather check for today and checks what kind of clothes you should be wearing and gives you recommendations based on your plans for the day? So could they pay like $10 a month?
If it, uh, I don't know, I'd have to research that one.
Right.
It would, yeah, because you can't then argue it's fair use. So then you'd have to or you can't argue it's non-commercial fair use. You'd have to make the case for nominative fair use, and that's, got a lot of, you have to make sure that nobody assumes you're a part of Gucci or being paid by Gucci, you're affiliated with them. It's tough.
Yeah, and I imagine that some developers might be deluded into thinking that Gucci's going to buy them out once they get their app working.
Right.
A lot of companies,
Right.
a lot of people will follow company news. But yeah, Jeff, I did hear you when you said maybe he'll finally realize no one's listening, no one can hear him. So I did have to leave and come back. But Ragu, your point was well taken. And just to finish, I was talking about there was a case with State Farm where the guy was like going to work for State Farm, ended up not pursuing it, and he had the domain with statefarm.com. He ended up just giving it back to him, so it was a transfer. But that's the kind of case that look at to see, is it interesting? The guy just gave up. But usually when we see a big brand in the domain name and it's somebody's basically just impersonating, we're pretty easy and straightforward, and we would all agree, us three on stage, the whole crowd would think, yeah, that's a transfer. So I will include some of those just so we can show when everything is in the favor of one party and usually the complainant, as opposed to we try to find when the respondent has rights. But thanks for bringing that up, Raghu. It is important because I do the exact opposite. I always try to find cases where it's not simple. But I think obviously I've overlooked sometimes the simplicity. The simple ones are important too. All right. Hey, once again, tomorrow there's an ICA webinar. You can go to our website, dnlshow.com/outline, and you can find a link to sign up for that webinar. You need to sign up. I know Zach is sort of moderating it. Great panel, and we're going to talk. They're going to talk about gTLDs in the next round. So it's perfect timing, especially if you know somebody who's interested in applying or interested. Sign up for this. Then I'll see you on Thursday in the DNX show. I'll be broadcasting from Vegas. So hope to see everybody then, or talk with you online on the DNX show on Thursday. Until then, have a safe rest of your day. Enjoy the rest of your week and hope it's productive. Take care.